Hello YouTube, I am Vince White. I am an employment attorney, and we on this channel generally answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. But here today we're talking about news, important news. And I was talking to reporters about this morning because it is getting bigger by the minute. So you'll perhaps recall, if you're a fan of the channel, recently the NLRB had a finding, a split decision, 2-1, that claimed to invalidate certain NDA clauses in severance agreements and things of that nature, under the logic that the NLRB is empowered to ensure that employees are able to engage in activities, to organize unions and things of that nature, and certain provisions in non-disclosure agreements could impede that by impeding their ability to share their stories and communicate freely and things of that nature. At least that is how I read the logic empowering the NLRB with the power to fight the veracity, the legality of non-disclosure agreements. And that happened a couple weeks ago, and then General Counsel of the NLRB, I believe her name is Abruzzo, but I hope I'm getting it right because she is a star, released a memo very recently saying, hey, that finding from the other week, it's retroactive. So like all the NDAs forever and always are impacted by that finding. And that is a wild statement. That's aggressive. And one might ask oneself, does that general counsel have the power, with a stroke of the pen, to alter U.S. law for all time? Noting that she was not an elected official. She is not a congressperson. And yet she has made, essentially, a vast and sweeping change in the law for the entirety of the U.S., potentially for unionized workers and at-will workers, which is something else we have to talk about because New York State is flirting with the idea of departing from at-will employment. That's a whole separate video. But today we're talking about this finding and how it's retroactive. And I've received many calls from reporters, from people who want to get out of a non-disclosure agreement, many questions about this. And my answer has been over and over and over again, well, this is an amazing thing that the General Counsel has done. The General Counsel is a star, doing employee-centric things, helping make the world better. I just don't know if the federal court system is going to be ratifying all of this when the rubber meets the road, so to speak, right? When this is actually put into effect. Which is tough because there are people who saw this memorandum come down from the General Counsel who said, oh, great, non-disclosure agreements are now no longer viable. I can do whatever I want. I can breach without fear. And they went out and breached and shared things that they had previously contracted not to, while subject to a 7-figure liquidated damages provision if they breach. And when those folks call me and say, hey, I'm still good, right? Well, we don't know yet. That's the terrifying truth, is we don't really know yet because this hasn't met a court yet. Not a real court who can decide if the NLRB actually had the power to do that, and if they did it in an effective manner, and what the law is today. Now, notably, we do have a somewhat conservative federal court system in some ways. And generally, lawmaking is the purview of the legislature, Congress, not an unelected official, right? So there's some arguments to be made that perhaps this is not a power that the NLRB actually had to exercise. Maybe it's just something they wrote, but it doesn't mean anything because nobody gave them that power. I don't know if that's the case or not. I don't know how courts are going to find this. I hope, ideally, that Congress would swoop in and say, hey, we ratify that. So that's the law now. Because I don't love an unelected official making sweeping changes in law for the country because they can. That's concerning. But I do love the sweeping change that was made in the same way that I love the FTC randomly saying, hey, non-competes are not a thing anymore. Does the FTC have the power to do that? Probably not. Do I want that to be the law of the land? I absolutely do. We're in the same position here. I have another question. Why? So these are people who are appointed by Biden, largely. Why is the Biden administration not taking credit for these things? In some ways, you could argue that these are among the first positive things the Biden administration has done for workers. The Biden administration has not been a particularly employee-friendly administration so far. Exhibit A, their behavior towards the rail workers during last fall's strike. And generally, their behavior towards Striketober of last year in total. Like, this is not generally what I would like to see from a pro-worker president. A president who largely got to office on the backs of unions and organized labor, right? I think I've made a couple of videos over the years saying how betrayed I've felt by the Biden administration and their, frankly, aggressive to labor stance, right? You can point out a few exceptions to that, but in balance, he's been far worse for organized labor and for employees in general, in my opinion. Now, if that is no longer the case, if these unelected officials, these Biden appointees, are carrying out the Biden plan for workers, can somebody tell us that is what's happening? Can we know that Sleepy Joe is at the wheel and is doing good things? That would be key information, right? That would, if we could take a break from talking about blank checks for war and have a conversation about, like, hey, you like that non-compete thing I did? You like me striking down NDAs for all time? Was that cool? I did that. I did it. It was me. Like, come on, take credit. Take credit. This could be the most impressive thing this administration has done in many ways. Storytelling is so meaningful, right? If you have workplace discrimination or workplace sexual harassment and you experience that and then you were silenced by your settlement agreement, the world then does not benefit from the empathy that might have grown from you sharing your story. Human beings tend to change the way they feel. Hearts and minds tend to change based on stories. Me, I'm playing whack-a-mole. I run around smacking people around until they give my clients money. But when they sign an NDA, then the story never gets out. Am I changing the world? Probably not. On rare occasions, maybe, right? The stories are what change the world, what change hearts and minds. So this non-disparagement movement, this weakening of non-disparagement agreements, is vastly meaningful for society. Like sweeping implications for the future of the human race. Like, I don't think I'm overstating it when I say that. So, is it just a rogue general counsel at the NLRB? Is she just planting her standard in the ground and being like, come on, let's go, I'm gonna fight you all? Is that what's going on? If so, how do I rally to her banner? How do we support her, right? But if not, maybe this administration should take some credit, get some benefit, and back her up, right? But I shouldn't make this political. Now, there's some other stuff in there that concerns me a lot. this memorandum that she wrote. You can find it online. I'll link it down below. She talks about non-disparagement provisions and how they're still going to be valid in certain cases, in terms of like protecting an employer against defamation. Okay, I have questions. About that. So we already had, in most jurisdictions, defamation laws. Why do you need a contractual right to sue someone for defamation when you already have the right, if they lie about you, potentially, if they meet the elements of a defamation claim where you are, you could already sue them. So what does that mean vis-a-vis what portion of non-disparagement provisions are going to be allowed going forward? Are we just getting into this gray area that will generate even more litigation? Because that is still a problem, because the litigation is in fact what silences people. The cost of defending a lawsuit, not the lawsuit. People don't stay silent because they're afraid they may ultimately lose a lawsuit. Generally speaking, they tend to stay silent because they're afraid they're going to be litigated to the ground and they don't have a couple $100,000 to defend a defamation claim or a breach of non-disparagement or a breach of confidentiality or a breach of an NDA, right? Like, these are claims that generate litigation. And when you have gray areas, that generates more litigation, and it generates non-frivolous claims that employers can bring to silence people even if they don't believe they'll ultimately win. So I'm hoping that our star, the General Counsel, can clarify a few things to remove some of that chilling effect that's still in the market today, and then get this in front of a court and make sure that it passes muster so that we can actually confidently tell employees, hey, you can probably share your story now. It's a lot safer than it was 6 months ago. That would be amazing. I'd be so excited about that. And it would be good for humanity. Legitimately, without question, good for humanity. Believe it or not. That's my take on this. And now I'm going to send this video to all kinds of people who keep asking me my take on this. But I figured I ought to give it to you too, because, well, I'm going to give it to reporters. Might as well give it to you. Like and subscribe. Helps me to help more people just like you. Remember, everybody works, not everybody wins. And it's good to be back. Back from Miami, from the conference.